This program is brought to you by Connie Dodo of Connie Dodo Realty Group, 119 Pleasant Street, Methuen. When you want results, don't make a move without us.
Thank you for joining Dodo Real Estate View. I thank you for the topics that you have submitted for us to have on our monthly show, and thank you for the questions that you ask in terms of real estate questions. We have today that people have requested that we have estate planning here, and we have Kelly Longtin here with Deborah Care Legal Services. Thank you for coming, Kelly.
Thank you for having me.
Kelly, just a bit about Kelly's background. She is an attorney, a state attorney, and she's been doing this, and she has a family, which she certainly can understand the importance of estate planning, having children, and having to make sure that their needs are cared for in the future and so forth. So with that, why don't we just talk about what is estate planning? I mean, people seem to have different understandings of what that actually is.
So there's different types. You can have a will, which would guarantee probate in order to get the assets to whoever it is that you designate. Or another way to approach it is a trust, and we specialize in trusts at our firm. So we also do probate and trust administration and elder law issues. But as far as establishing trust, it's to pass your family's assets from one generation to another and to make sure that they stay in your family. So it reduces taxes. There's no probate when you have a trust.
Okay. Let's talk a bit about probate, and then we'll get into some of the intricacies of trust. Because a lot of people, you hear these words. I know in real estate, we hear a lot of people say, okay, it has to go through probate, and people don't understand what that process is. So maybe if you could kind of dissect that so the public understands, what is probate?
Okay, so when you go through probate, it's the court deciding who's going to own your assets. So let's back up a little. I'll explain the difference between a will and a trust. Mm-hmm. So if you die without a will, then you will go through probate. If you die with a will, you will still go through probate. So the process of probate is the court deciding who's now going to own the assets that you own. And that's the only person that can decide it is the court. So if you think of a will is a set of instructions to the court on what you want done with your assets. But it still has to go through the court to change title. When you have a trust, you actually change title when you're alive. So there is no probate process because the trust now owns it and it will go directly to your beneficiaries.
Okay, so to kind of as lay people not dealing with this on a day-to-day basis, obviously that's why we turn to you to help us get to where we need to be and formulate what's best for that individual. A trust, who should get a trust, who should get a will? Is there a particular profile, person that should have it, or?
Honestly, in my opinion, anyone with any type of assets who wants to have their family avoid probate, why pay the court fees more than you would want to when they could be avoided if you set up a trust to begin with. If you only have a will, it's a guaranteed probate. It has to go through the court system. Mm-hmm. And there's also a time factor. It's at least a year before those assets can be transferred over. And it's the cost. And wills are public, so anyone can find out what's in your will. And there's been lots of celebrities who have died with just wills, and they find them in the newspaper the next day with every detail printed out. If you have a trust, it's private. So no one ever needs to know the assets that the trust owned or who received those assets.
Well, I didn't know that about a will, that it was public.
Yeah.
That's interesting. Now, in terms of cost, if you had to go through probate, say a typical cost, I mean, I know you can't, I'm sure every situation's different, but what would be an average cost?
Yeah, you can't even speculate on average because it depends on the size of the estate. Mm-hmm. But it's costly and the time. So it's at least a year because you have to give people time to contest a will. And that's another feature or con of a will is that people can contest it. So you might have an instruction to the court and there's people that can say no, that they don't want the court to give that person that title.
So as you're saying, it sounds like wills are not much more than writing it down. It doesn't protect anything.
Well, it gives the court instructions on who you want to receive those.
Yeah, but somebody can always contest it.
They can.
And
Yeah.
if you contest it, what's that process and how much more of a delay is that impacting that closure of that will?
Well, it's ultimately just a court procedure, just like any other court procedure. So they'll come in and give their reasons for contesting it, and ultimately the judge will decide who's going to own it. When you have a trust, it's not public knowledge. So a trust is actually a contract. It's governed by contract law. So there's three parties to a trust. There's the trustors. Those are the people who are creating the trust. There's the trustees. Those are the people who manage the trust. And then there's the beneficiaries, and those are the people who benefit from all of the assets that are in the name of the trust.
Now, the trustee, who is the trustee typically?
So if we talk about, our most popular trust, which is the Family Wealth Trust, let's just use you for an example. If you set up a trust, a Family Wealth Trust, you would be the trustor, you would be the person who is creating it and putting the assets into it. You can also manage your trust, and you can also benefit from your trust while you're alive.
With that being said, it sounds like there's probably some good tax benefits to doing it that way?
The biggest concern, there is tax benefits between spouses. In Massachusetts right now, there's an estate tax of $1 million, but the federal exemption is $5 million. So you wouldn't pay a state tax in Massachusetts if it was under $1 million right now between spouses.
Okay.
So the biggest positive of it is that your beneficiaries, and in a lot of cases it's a couple with children or anyone with children, and they want their beneficiaries to avoid probate. They want them to get specifically what they have wanted or desired in the trust. And the trust can be written to say absolutely anything. So if you wanted to, our biggest concern of our clients is divorce protection. So we can actually draft a trust that protects your beneficiary in the event that they went through a divorce. Whatever money that they received in that trust would not be considered a marital asset. So they get the protection of a divorce, where the divorcing spouse would never have access to that money that was left to them in a trust.
Really? That's interesting. I would have never thought that either. I mean, the two things that, when I have people come on the show, it's great because I learn as well as, people out there, so you never think of it, the will and then the divorce, that would protect your beneficiaries to that.
Yeah, your trusts are extremely beneficial in protecting your assets, so they flow stay in your family and straight to the beneficiaries who you've designated. We also can make provisions for if you have someone with special needs and they need to get benefits from the state. We also can draft trust where that wouldn't affect their ability to qualify for benefits. And another trust that we do often is a type of trust where you can protect if you have a child who is, maybe a little irresponsible still. Maybe they are a spendthrift, and you're worried that they're going to get their assets or their money from your estate when you pass away, and they're going to spend it all and go buy a new car. So that we can draft it in, to fit the needs of all of our clients on an individual basis on what it is that you want.
Which I've heard that people get certain monies so much a year.
Yeah, you can stagger the
wanna,
distributions.
Yeah.
Some people do 1/10, a year until the 10 years is up. It all depends on, the situation of that client and what it is that they desire to happen after they pass.
Do most people manage their own trusts, or?
If we're talking about
Typically.
a Family Wealth Trust,
Yeah.
which is our most popular, we also have trusts that protect from what we call them Medicaid, that help protect in the event that you became disabled. But in your typical Family Wealth Trust, you want to keep control of your own assets. So you're putting them in the name of the trust, but you still control all of the assets. You can sell them, buy them, sell things, buy things, invest in stocks, bonds, whatever it is. So typically, if you're establishing a Family Wealth Trust where you're the trustee, which is the normal course of action, you can still live your life basically the same way you did before you established a trust. It's just now protected.
Now, is it true that the beneficiaries, they don't know who they are? You don't have to, typically that's
Well, in a family wealth trust, you would be the beneficiary right now. So when you create it, you actually hold all three positions. You're the creator, you're the manager, and you're the person that benefits from it. It's your trust. You can decide whether or not you want to tell your beneficiaries that they're benefiting from it or not. But it's not ever going to be in the court system because there is no probate when you have a trust. So all of those assets will go straight to the beneficiaries.
Now, if you put a home in a trust, let's talk a bit about that, because frequently that's a piece that we talk, obviously, is real estate, that people say, I want to put my house in a trust.
So that's actually a simple process of just redoing the deed and re-recording it in the name of the trust. So if it was Connie Dodo's house, it would now be Connie Dodo trustee of, let's just say, the Connie Dodo Family Trust. So you would just hold title as the trustee of your trust.
I mean, I've heard people say that when you do that as your dwelling, that you have to have utilities and stuff be written to that trust. I mean, is that a misconception?
No, you don't have to have the utilities paid out of the trust.
Okay, because I've heard that. I've heard people.
That may be a different type of trust.
Okay.
I could see that happening in a different type of trust, which would be called an irrevocable trust, where the trust would have to pay the bills. But in your typical family wealth trust, that's not the case.
Okay. I mean, like you said, you were saying the most common trust that you deal with is family.
Is the family wealth trust. And just to talk a little bit about the types of assets that you would put in a trust. A home would be one of them. Timeshares, bank accounts, stocks, bonds, anything that holds title to it, you would want to put in the name of the trust, because that's how you avoid probate.
Right. And I mean, that's what you hear always. People say, I don't want to deal with probate. You touched a bit upon Medicare and disability. How would one avoid, say, if you have to go to a assisted living or nursing home, is the trust an envelope to protect that, or?
It definitely is an envelope. So in the Family Wealth Trust, we have language in there that allows us to implement strategies to help protect your assets in the event that you had to go into a nursing home. In an irrevocable trust, after 5 years, the property that you put in there is no longer considered your property. So that would be 100% protected in the event that you needed to qualify for government benefits.
So that's where you definitely would, you wouldn't be, when you explained the beginning part of you being the three owners of the beneficiary, the trustee and the trustor, whatever, did you say trustor?
Trustor, trustee,
and
beneficiary.
beneficiary. So if you were those three, you wouldn't be positioning yourself to avoid Medicare.
Correct. So in a family wealth trust, you would hold all three positions. In an irrevocable, you most likely would not, depending on the state.
Okay, and that's probably where you'd have beneficiaries. So it'd be not.
You would have beneficiaries of all of the trust.
Okay.
Yeah.
Okay.
Yeah, but in order to qualify for government benefits, there's a 5-year look-back period. So if you had to go into a nursing home and you filled out an application today, they would look at any assets that were in your name from 5 years prior, whether or not you sold them.
Wow. What age can you do a trust?
This question comes up a lot. So most of our clients or the majority of our clients have close to retirement age. The kids are out of the home, but we've been seeing more and more clients who are in their 40s who are worried about what if something happens, and how will their children be taken care of, and how will the money go to their children. So that has been an age bracket that we've been seeing more and more of, where they're starting to think, I know for myself, I have teenagers, so that's a concern of mine.
Right.
So it's, definitely 40 and up is where we see it happening. But a majority is around retirement age. But more and more we've been seeing couples in their 40s come in and set up trust because they just want to make sure that their assets pass to their beneficiaries in the way that they wanted to and without probate.
Right. But legally, is there an age?
Nope. Nope. And that's the thing about Trust is just a contract, just the same as if you had a contract with your gas company to deliver oil or whatnot. It's governed by a contract law. So the trust wording and the language, which is super important, is what governs the way that your assets will be dispersed when you pass.
So if you have a 12-year-old that comes into you and says, I want to do a trust.
We would have to be an
Your
adult
parental?
to sign it.
Oh, well, that's what I'm saying, you need parental, okay. That's what I mean, it's like, you know,
I don't know what
obviously
kind of
would need-
assets they would have to put in
Well, you
there.
know, some of these entrepreneurial kids selling their slush or whatever, they make some money.
And then they probably don't have any children that they're worried about right now.
In talking about estates or trust, why do most estates fail?
They're poorly drafted. They're not maintained. So if you establish a trust when you're 40 and you haven't revisited.
I'm not there yet.
I know. That's why I said
Right.
I know. Well, when you turn 40,
Okay.
we'll talk. If you establish a trust when you were 40, life changes. Laws change. So the trust needs to be reviewed because if there's a change in law, it needs to be updated. It needs to be amended. Your life changes. So who you want as your beneficiaries when you're 40 may not be who you want as your beneficiaries as you become older. So maybe initially you have your children as the beneficiaries, and maybe as 20 years later you may want to change it and have your grandchildren as the beneficiaries. And with the Family Wealth Trust, you have the ability to change any part of your trust at any time.
So that's the maintenance. Now, who would change it?
You board as the trustor.
Okay, so you'd have, you're a company.
Yep, you
It
can
would
just
be-
come in and we'll update it and make the changes. And we like to review with our clients every 3 years anyways. We invite them in to sit down and go over, how has your life changed? Because life changes quickly sometimes. And just look over and see if there's anything else that we need to. Maybe you had a child who, suddenly became an alcoholic, and maybe that was a concern of yours, that they weren't going to be able to manage their money that was left to them. So that's something that we can address by changing the trust and making sure that that doesn't happen.
So none of this is, I'm just trying to wrap my head around, none of it's recorded anywhere.
Nope.
And it's legally binding,
It is legally binding, just like any other contract would be.
So, say you have a trust,